Thank you, Convener. Good morning, Lord Gill.
Carlaw,
Can I say how delighted I am that you're with us this morning? When this petition first came before us in 2012, I have to say I thought it rather vexatious. But we went through the normal process that we do and initiated the inquiries as is our wont. And what surprised me, given that you had a record of giving evidence to other committees of this Parliament, and given that there's nothing terribly controversial in the evidence that you have given us this morning in response to the actual petition, was why you felt it was inappropriate to comment to the committee at that much earlier stage before this petition started to gain attention and momentum in the media, and to meet but only privately with the convener and deputy convener, as was of the committee, and presumably to say to them what you've said to us today, all of which unfortunately gave wind to those who felt that there was something slightly paternalistic in the approach that was being suggested, which was one of, well, I'm not terribly interested in discussing this. I have told you that I think it largely a bunch of nonsense. Please accept that to be so and carry on, if I can put it like that. So I'm interested in what was the reluctance and what do you feel could only be said in private that you feel able to say today?
Well, I don't know if it was you, Mr. Carlaw. I think it may have been you.
I probably added a bit of colour.
You said that I looked down upon the hoi polloi, and
I freely admit to a bit of colour in order to compensate for the magisterial response we had received, Lord Gill.
Well, I think your remark might have come as a surprise to people who know me. But you know, this is all water under the bridge. We can't keep harping on about this forever. The main thing today is to discuss this petition, which is what I'm here to do. But anyway, you've asked the question, and I've got a jolly good answer for you, so here it comes. The point was that in 2 detailed letters, I set out my reasons why I was against this petition. I hope, and I think, that I set those reasons out with the greatest of clarity. I had no further reasons to add to that, and therefore I was quite satisfied that I had placed before this committee all the help that I could give it. Now, I've appeared numerous occasions before the Justice Committee in this very room, so it's not as though I have an aversion to appearing before committees, and I have to say I'm very happy to be here today, and I'm enjoying this stimulating conversation. But having given you all that I could do, there was nothing to be gained by my coming here, and I had also to consider the office of Lord President, which I then held, and my judgment was that it was not a situation where, under the Scotland Act, it was necessary that I should come here for examination before the committee. That was the view I took. I'm aware that you take a different view, and I hope that in differing on that, we won't fall out.
Oh, I'm sure we won't.
Well, thank you for that.
And but obviously you then did meet privately with the convener and the deputy convener to explore the very issues of the advice that you felt you had given us. And I only suggest that in so doing, it created, beyond this committee, an impression that there was a reluctance to bear witness to the advice that had been given, or to allow us to explore with you the contrary advice that we had received, which again this morning you've dismissed from the former chair of the JCR.
No, I think that is a highly over-dramatised view of what I did. It seemed to me that since there was concern among the committee, it was perfectly reasonable for me to meet the then convener discussed what his concerns were. And what came out of that was really quite helpful, because I was able to tell him things he didn't know. I told him, for example, that if he wanted to know what all my assets were, then he could go to the Scottish Courts website and get them, and he didn't know that. And I also told him that I was perfectly happy, if it would help, to institute a recording system for recusals. And he said he thought that would be a good idea. And I went back to my office, and my staff duly implemented that.
Okay.
Have you got any questions for me about the merits of this petition, Mr.
I do actually remain broadly sympathetic to the views you expressed.
Yes.
I simply say to you that I think that it was unfortunate that that we found ourselves in the position that we did. You spoke movingly, and I have to say,
Mr. Carlaw, look, this is water under the bridge now.
That's why I'm moving on.
About this petition. Well, please ask me some questions about the petition, if you may, because I think that really that's what is the most profitable use of time.
Well, I'll ask questions on the petition and also on the remarks you made in opening and in response to the answers that you gave. If you'll forgive me to allow me to frame my own questions rather than have them suggested to me.
No, please do.
You spoke movingly and with conviction earlier about why you felt this a petition was inappropriate and unnecessary. And I would suggest that probably representatives of each of the professions who have ever found themselves the subject of a register, their leaders would have said much the same about the character of the individuals with whom they themselves kept company. That in itself was not an argument against the register. You said that it would put us out of step with the rest of the United Kingdom, which is something of a monkey see, monkey do argument. Scotland has led the way in a number of different aspects of legislation, and the fact that other parts of the United Kingdom have chosen not to do something is not in itself an argument. And I simply ask you, despite the eloquent way in which you spoke about the character of the individuals involved, uncomfortably for us both perhaps, do we not live in a more cynical age in which transparency and the aims of the petition as set out have become part of commonplace life and that which many of the public now expect of us, irrespective of where we find ourselves serving?
Well, you may be right. It may be that the public, it may even be that the legislature is in a more cynical frame of mind than in the past. That may be just an aspect of the modern world, but I know of no example of a case where this register would have prevented it from occurring. And as far as I can see, any problems that are likely to arise in this area are exactly the sort of problems that this petition would not address. And what I've mentioned to you is the most common one. And that is the case where the judicial office holder either knows one of the parties or knows one of the witnesses. And a register is not going to pick that up. The petition also mentions the New Zealand situation, and of course, as the committee may know, when the proposal was put to the New Zealand Parliament in February, it was defeated by 104 votes to 16. If you don't have the documentation about that, I'd be happy to make it available. I read it up in preparation for this meeting. And in that case, it arose from a most unfortunate situation where a judge in a case actually owed money to one of the lawyers. Well, obviously it was deplorable that such a judge would sit in that case, but I think you'll appreciate that that would not be caught by this register. So what it really comes to is this, that this register does not meet what appear to be the concerns, and on the contrary, there is just no evidence basis to support it.
Okay. And finally, thank you, Lord Gill, because in essence, your argument, beyond all others, is that the actual objective as established in the petition by the petitioner would not actually necessarily satisfy the objective he potentially is trying to seek.
That is my view.
Yeah. Can I ask you then just finally, and given that you accepted that we may live in a more cynical age than either of us might wish that we did, is there in your mind something further yet which might arise in the foreseeable future, in the most general of terms, which might give further public confidence? And given the illustrations you gave of the oath and the process that currently exists, do you think that that in itself is properly understood by the public in terms of the confidence that they can take in the judiciary?
Yes, I do. I feel very strongly that the people of this country have a judiciary whom they know and they trust. And it is one of the reasons why one would want to live in a country like this. It is important that the public should know that the Scottish judiciary enjoys a reputation throughout the judicial world that is out of all proportion to the size of our small nation. The influence that it exerts in judicial thinking is enormous. The Scottish judiciary is admired, it is respected, and it plays its part in the international world of judicial affairs. We should be very proud of that. It's one of Scotland's best assets. And it would be such a tribute to our judiciary if this committee were actually to acknowledge that by its decision in this case.
Okay, thank you very much.